following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of investment in the Sri Lankan legal landscape. How conducive is the current context for international attention? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Today's topic is something I'm sure a lot of us were interested in, but due to the vast nature of it, not many of us have gone past the surface level to actually understand how much of a key role it plays in specifically Sri Lanka's economy and also the future of Sri Lanka's development, and that's on investment. And to speak on this with us, we have someone that I believe is the most well suited for this specific topic, and that is Ms. Renuka, Weerakone, attorney at law. Thank you very much, ma'am, for taking the time to come to our studios here today and actually explain these topics to us. We have a lot to cover as well. A little bit of an introduction onto Ms. Weerakone. She is the Director General and CEO of the Board of Investment of Sri Lanka. So safe to say we're in good hands when it comes to navigating the fields of law relating to investment in Sri Lanka specifically. So before we get into the topic, here's a bit of a breakdown of how we're going to actually really give you the concise updates onto it. First, we'll be talking about the very basics and fundamentals, the legal frameworks and what they are for. And finally, next we'll be talking about the investor rights, their protections, and also about dispute resolution, the nitty-gritties basically. And finally, we'll be talking about the future of investment and development in Sri Lanka.
Hello, my name is Nikma Karyavasa, currently working as a demonstrator. My question is on fundamentals. What laws govern investment in Sri Lanka?
All right, well, without any further ado, let's get right into the discussion. We have a lot to break down today. Once again, ma'am, thank you very much for trying to attempt to actually understand and, break down and explain to our viewers about the very vast area of law that we're trying to really get clarity on recently. Before we get into any of the current specifics and the context, I'd like to ask you about the most fundamental question, which is, of course, on the legislation, the fundamental statutes that govern investment, specifically foreign investment in Sri Lanka. And I'd also like to add on to that question to ask you, are these statutes and legislation that we have seen on par with international standards?
Yeah, thank you, Anuradhi. It's a pleasure to be with you. I hope I can give some context to the questions that you're asking. So when you look at the foreign investments and the legal statutes that govern it, fundamentally the Board of Investment Law becomes one of the key legislations that are applicable in this area. So if you look at the Board of Investment Law, which came in 1978, formerly known as the Greater Colombo Economic Commission, it was mooted. I think we were one of the first countries in South Asia to open out our economy for foreign investments. So it was an area of authority that was demarcated specifically in the Gampaha district, covering Katunayaka and Weerakone. And so we also through the GCEC law, it enabled the organization to establish export processing zones. So it was in context of setting up the zones and attracting investors to this particular area to set up their manufacturing projects for exports that this was mooted. But with the passage of time and with the needs of the country, the need for expanding beyond area of authority arose. And in 1992, the amendment to the GCEC law brought about the Board of Investment, which gave authority for the organization to give approvals for investments anywhere in the island. So that became a key law, and the exemptions that the BOI could give through the schedule that was gazetted in that particular piece of legislation was that we could give exemptions, or we could modify, or give half kind of modifications or alterations to laws such as the customs, the inland revenue, and even the exchange control law of the country. So that was the benefit that investors would get through the BOI law. And of course, the Foreign Exchange Act is a key piece of legislation again, because that stipulates, and the BOI also is guided by it, it stipulates the areas that where there are exclusions for foreign investors to come in. For instance, currently we only have 3 exclusions, one for pawn brokering, and as well as for retail trade where the investment is less than 5 million USD, as well as for coastal fishing. So those are particularly not accepted other than the retail trade if you do invest over 5 million. And then there are also areas where there are limitations spelled out in the Foreign Exchange Act, where the foreign shareholding is limited to 40%. So if you look at, say, mining or deep sea fishing or primary processing, timber-based, so any of these industries, to name a few, cannot have foreign shareholding over 40%. But there is a provision for the BOI to evaluate such projects, and if we think it warrants giving them over that threshold, BOI is empowered to do that. So those two being key areas and key statutes. There is also, of course, the Finance Act, the Commercial Hub Regulations, which are key for a foreign investor looking into Sri Lanka, as well as the Strategic Development Projects Act, and of course the newly introduced Port City Economic Commission law.
Exactly. I think we will most probably, specifically in the area of investment, specifically we'll actually see a lot of development when it comes to new laws and legislation put up, especially as you mentioned the Port City bill as well. That's seen a lot of development over the past few years. You know, it's not in its embryonic stages anymore. We can see practical implementation soon, I'm hoping. I'd like to just catch on a little bit of a point that you mentioned previously, ma'am, out of curiosity to check, of course, the BOI's scope and its you know, legal heavyweightness has actually increased over the years depending on the necessity of in the Sri Lankan context. Could you please explain to us how the BOI actually balances that fact? Now you mentioned of course the 40% shareholding for specific industries as well. It's almost to ensure it's not protectionisms per se, but there is some sort of a balance that is sought to be achieved within local industries and foreign involvement. If you could give us a little bit more context into this, ma'am.
Yes, so for example, if you take the area, the sector of mining, so there again, this is a sector where we, under the foreign exchange, only 40% shareholding can be accommodated. But when you see the investors who want to come in with value addition, the capital cost is very high. So there are instances where actually if they are looking for a local partner, the local partner may not be able to contribute as much for that venture, and that itself would make that venture not possible. So we look at the credibility of the investor, their financial capabilities, and then again we have a very strict criteria which we go through to see versus the investment plus the value addition plus the revenue that would be generated, where we have a marking scheme to say, okay, this particular sector, this particular investor can maybe have 70% and have a 30% local. So we are very conscious of the local industries and the local national interest. So and the BOI, I must tell you, whenever it comes to a particular sector, we always consult the relevant agency or the authority. So here it would be the GSMBA if you look at the mining. Similarly, any other sector, we work in close consultation with those agencies to see that that what we approve is something that can be implemented.
Right, and it's good that there is a balance, and the BOI is, you know, practically looking into every aspect before there's some sort of implementation. It's not just a bureaucratic process. It's an overarching a thing. I think I'd like to delve a little bit more into the FDI perspective. We just got a little bit of insight onto that. If you could give us more clarity on how exactly the BOI really, what kind of role it plays when it comes to foreign direct investments specifically from a legal standpoint, ma'am.
Yes, so under the BOI law, there are two ways that the approvals for investments can be granted. One is under section 16 of the law, which allows for an investor to come and set up their operations under the normal laws of the country. So what they would get is just a letter of approval after having vetted their application and them having set up a legal entity in Sri Lanka. we give them permission, yes, you can operate under normal laws. So there's nothing that they would get that a local would not be enjoying at that time. The other method is through the section 17 of the BOI law, where we confer concessions and other benefits, like there may be duty-free imports and such. So, and in that instance, we also sign an agreement with that company stipulating what is the investment they should bring in, as well as what are the concessions that they will be offered, the benefits and concessions. So this is the legal framework with which we work with foreign investors, and that gives them a lot of confidence, because that agreement they sign with the BOI is valid for the lifetime of their project, and the clauses that have been incorporated into it will also remain valid immaterial of changes in governments or any other legal situations. That agreement is honored.
I think that's a very important point as well, specifically when it comes to the significance of the BOI law and its applicability. We can't say that it has any sort of less of a significance to other laws that we are seeing that are being practiced right now. It's something that holds its own weight and actually ensures that there's no sort of, funny business that goes on, loopholes maybe that we could see. Of course, in the public perception, there's always that animosity towards foreign investment. Specifically, we've seen it through the years as well, but of course it's slowly dwindling down and public perception is improving. But it's of course very important for us to get an understanding on why exactly we need to facilitate foreign involvement and foreign injection into our economy as well. Moving on with this specifically, ma'am, now national interest, the protection of national interest specifically when it comes to investors. How exactly does Sri Lanka's currently existing investment law really balance this, specifically when it comes to strategic investments?
Yes, so Anuradhi, actually Sri Lanka, as you may know, has signed 26 bilateral agreements, and we also have FTAs, as well as, even in our constitution itself, there's a guarantee for the protection of investments and for any kind of actions taken against or having to take over any kind of a foreign investment. There is provision where they would be compensated. So that is very clear, and through the BITs itself, their investments are protected. So the investors with the investor countries with which we have signed the BITs, investors of those countries actually are very comforted to know that there is a bilateral and that their interests are protected. Actually, just yesterday, I wouldn't name the countries, but we were at a discussion with a foreign delegation, and so they were just alluding that we just signed with UAE, and they were saying, oh, you have signed with UAE, what about our country? And then we told them, no, we have signed with you much earlier than this. So, they were very happy to know that, and the confidence to know now they can go and tell their business people.
There's a safety.
There is a safety, there is a treaty between our two countries. So it plays a big role when we are trying to attract investments, because it gives a legal grounding for them to know that their investments in the other country is protected. Not only for them, but for our investors who go into those territories as well.
Exactly. It's good to know that the current standing practices that we have in Sri Lanka are enough for international organizations or countries even to actually be resting assured that they don't have any sort of unfairness on their end as well. I think that's an important point. We had that little bit of a question in the first bit that we were discussing where it comes up to international standards. We do have to get into the reforms aspect towards the end of this discussion, but before we go in for a break as well, I'd like to ask you, ma'am, about that international standards aspect. How well do we right now, as a nation with its laws on investment, compare to the rest of the world when it comes to the protection of investors and also the balance of national interests?
Yes, so whenever there are discussions on either FTAs or BITs, it is widely, the consultation with stakeholders happens, especially for FTAs in particular sectors, because we have different interest groups and different associations with which the dialogue is there, the conversation is held to see that their views are taken in, and if they do have view that it could be a threat for them, then those are taken into account very much. So national interest is always foremost when negotiating happens. And I must tell you, like the bids that we have had up to now, there had been a model bid, which I think most countries, even India, has now actually pulled back on their bids because they want to renegotiate all of it with a new framework, with having moved with the times. So we in Sri Lanka also at the moment the model bid is under discussion, so that there would be a fresher template that we would be looking at, a better and more current and in terms of international standards that it would be looking at.
So we can see that there's progress in the right direction, where we can expect our country to keep evolving with the time so that we don't fall behind as well.
Yes.
I think that would be an ideal area to actually break off for a little bit, just to reconvene. Right after we get back, I'd like to ask you as well, specifically when it comes to the current context, and also a little bit on the nitty-gritties of investor disputes and alternate dispute resolution as well when it comes to the investment setting. But before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this.
Hi everyone, my name is Renuka and I'm the Associate Information Security Analyst. My question is on the current context. Are the existing laws conducive for foreign investment inflows?
Welcome back to Law, Land and Liberty. We're in our second segment in discussion with Ms. Renuka Weerakone, attorney at law. She's the Director General and CEO of the Board of Investment of Sri Lanka. Thank you very much once again, ma'am, for the previous segment. I believe we got quite a bit of a good fundamental understanding when it comes to investment and its current climate in Sri Lanka, and how we are actually appealing towards international investment through the updating of our existing principles and practices. Before we went into the break, I wanted to ask you, of course, I had to unfortunately cut you off, one of the most key areas, I believe, when it comes to investment, which is balancing the parties appropriately, specifically when it comes to disputes. If you could give us a little bit of insight, ma'am, how exactly Sri Lanka's laws and the legal framework in Sri Lanka really address investor disputes, and also the mechanisms that we see that are in place specifically when it comes to alternate dispute resolution like arbitration.
Yes, so the dispute resolution, of course, happens through our legal system, and there is provision in our civil as well as the criminal jurisdictions if that is a need. And of course, we do have the special commercial high courts that have been set up now, especially in terms of the commercial disputes that could arise through businesses. And the high courts, the appellate courts, the whole work is there up to the Supreme Courts. So one of the key areas we as the BOI is also trying to drive is to look at alternate dispute resolution methods. And actually most of our legal team in the BOI is also being trained with the help of international agencies in this area to be able to advocate that to the investors, because when it comes to dispute resolutions, we do have a clause in our agreements which we have incorporated, which allows them to go for arbitrations and or mediation prior to that. But we are trying to see whether we can maybe convince investors not to have that clause, but to even look at mediation or alternative dispute resolution as a first method, because that would, I think, be more cordial and it wouldn't be as time consuming as we would want them to be having protracted arbitration cases or litigations, because the thought process when arbitration came in was it would be a quick process, but unfortunately we don't see that happening. So we are trying to look at different methods, and currently there are about 329 boards across the country for mediation purposes, And Sri Lanka is also a signatory, and we have ratified the convention of the Singapore Convention on Mediation. So the groundwork is there. So if the parties do want to go in that direction, the newest thought process is not even alternate dispute but mediation. So we are all working towards that to see how this can be promoted and socialized and taken on.
Exactly. I think it's very important to note as well, ma'am. I mean, we do have Singapore as a good example of how ADR can actually benefit an economy of country as well. As you mentioned, having alternate dispute resolution mechanisms be the first thing that you can turn to as an investor to resolve any dispute is much swifter, unfortunately, than the currently existing court system as well. On this same note, I'd like to ask you, ma'am, a little bit of a question related to it. When it comes to international arbitration, I believe at the current moment, Sri Lanka is not that much of a strong contender for being an international arbitration hub as well. As the Board of Investment, how exactly, as the Board of Investment how does it facilitate for arbitration and alternate dispute resolution apart from the plans that are being expected to be made? Are there any other presently existing mechanisms that we see can give some sort of relief to any sort of aggrieved parties when it comes to investments?
You're right. So, I mean, Sri Lanka also has a couple of arbitration centers. As you know, we have the National Arbitration Center, the International Chamber, the Court of Arbitration, and many others. And currently the ICC branch in Sri Lanka is also going ahead to establish another arbitration center where they think they can play a very catalytic role in terms of international arbitrations. Sri Lanka, as you know, is a party to the New York Convention, and we are also we have followed, our statutes are based on the United Nations Commission on International Trade Law, Model Law on International Commercial Arbitration, and we are also a party to the ICSID Convention. So knowing that 26 bids, 2 FTAs, and having investment protection provisions with in terms of APTA, BIMSTEC, all that do give weight for investors, give them that comfort, give them that confidence when it comes to this fear of arbitration and mediation.
Exactly. So while it is a little sparse, we still have quite a few means available where it can actually be a feasible reality for certain individuals and organizations to actually turn to arbitration. It's a little bit bare bones right now, but as you mentioned, of course, with the ICC coming in, we could potentially see some sort of updates in the near future as well. I'd like to move on, ma'am, on this when it comes to, of course, well, this is a little bit of a question that we've had specifically in the public perception as well when it comes to foreign investment and businesses and local investment and businesses. Sure, there's not a hard line segregating the two. There's a lot of flourishing businesses in Sri Lanka through foreign injection and also through local growth. But I'd like to ask you, when it comes to the legal requirements that foreign investors must abide to, is there some sort of key contrasting difference when it comes to the local legislation? Are there any sort of specific and special provisions that they must abide by?
Yes, definitely. So, I mean, just looking at the basic approval process, it would depend on the investment threshold. So, for example, if you look at a manufacturing project, an investor would need to bring in $500,000 US. And to bring that, they have to bring it through an inward investment account, an IIA account. So that shows the traceability of the funds coming in, as well as the banks would be looking at the trail, and they know their customer well. They will do all those the necessary background checks so that we know that the funds coming in is clean funds. And we also stipulate in our agreement that a foreign investor will not have recourse to finances through local banks. So it is a must that they bring it in through an IIA account. When it comes to the local investor, of course, they do have recourse to local banks, and they again have to meet that threshold of 500,000. So it's only the threshold that we look at, and very, very clearly we tell them that if it is a foreigner, it has to come in through foreign means. It's only after they commercialize and if they need any working capital, at that point they have brought in the funds, they have put up their factory, they have brought in the machinery, all that is done. But if they need working capital when they are in operation, then at that point they can of course have recourse to the local banks. So it's very clearly put out there, and the legal requirement is that they would have to incorporate a new company. You cannot, go with something that is already in existence. So those are the particular legal aspects. But I must also, I'd like to add, Anuradhi, that recently, having seen the need for non-BOI companies that are in operation, who are trying to come into the BOI portfolio, we have moved a new regulation where we have permitted, we have moved away from saying it has to be a new company. We have made a provision where the existing company can come into the BOI, where they have to show that they have at least invested 250,000 USD currently, and they would top it up with another 250,000. So that enables them to come in as the entity they are, and this has helped most companies that we have now seen. I mean, this was after like post-COVID, and people were struggling, they needed to keep their businesses going, but this barrier kept them from coming into BOI. So this has opened the avenue for foreigners also to come in and join them in their industry or their enterprise. So I just thought I'll add that in.
I'd like to move on, ma'am, now that we have a little bit of an introduction on how exactly foreign investors are expected to participate when it comes to the introduction of a new foreign business when it comes to Sri Lanka's context specifically, and how the capital is a very important part that plays in differentiation as well. I'd like to ask you on the same end as introduction, the consequences. Now, if there is a case where an investor fails to comply with the regulations that have been locally adopted, or specifically the investment conditions, as you mentioned, the numerical value, what exactly are the legal consequences that have been stipulated specifically by the BOI?
Yes, so Anuradhi, I mean, just going back to what we were speaking about, like the legal requirement, one is that they sign an agreement with us. So that agreement would tell exactly what is expected out of them based on the application they gave to us. So when you look at an investment application, we give them something like a 2-year window, a 24-month window to bring in their funds, unless it's a mega project like, say, Shangri-La or something where they would need a longer period. So when they do submit the application, they would say, okay, first year, first half we bring so much, second half X amount, and the second year, etc. So this is monitored very much by the BOI. We have a dedicated department to look into it, to ensure that the compliance happens. So when you look at the regulations by which we give exemptions, now previously we did have the authority to give tax holidays. So when we do give a tax holiday, we give a cut-off. It is very important that they bring in that certain amount of investment by a certain date. And in some regulations, it's not only the investment, but sometimes if you are, say, going out into a region and you get special, maybe a longer tax break, but you have to employ an X number of employees. So that is also a condition. It's not only the investment. So when, especially when their tax holidays are being granted, it is the BOI that would issue the certificate of tax, which is taken to the Inland Revenue Department. So if these companies have not met those guidelines in the stipulated time period, whether it is employment, maybe they have missed it by 5 people, but still they are not entitled to that tax holiday. So that is the repercussion of not meeting the given conditions of the agreement. But now we don't offer tax holidays, but we still have the conditions on the investment being brought in. What we do is, if we see there has been a lag, what we do is we send them a notice of non-compliance, because we see it beforehand, before that date comes up. And because our role is a facilitator, not to be a regulator and say close up and go, because the bigger picture of getting a foreign investor or a local investor is actually that you create employment. There's a lot of generation of employment, not only directly but indirectly, because there are so many services that happen through an enterprise. So what we advocate to them, and if they have issues, we try to assist them to see that they meet those conditions and keep them within the purview of the BOI. But there are instances we see that they really want to exit, or they, that they cannot, they don't want to be in this country, or they want to sell it out. Then in those instances, what we do is we will start a termination process of that agreement. And what that entails is that whatever the duty-free concessions they have enjoyed in terms of bringing in their machinery or putting up their structures, that is informed to the customs department, so that the duties that were waived earlier are recovered. So that is the consequence of not meeting the criterion, and when they're leaving, so all the dues are taken from them, which they enjoyed as being a BOI company.
Right, so there are proper checks and balances as well,
yes,
in order to make sure that it's not just an exit that does not, well, I wouldn't say benefit per se, but there is a consequence for non-compliance, and it's not just a foreign investment free reign. There is no such thing that we have seen in public perception come about quite a bit as well. There are regulations that they have to stick by, and there's an agreement that's been previously made, and the BOI works to actually make sure that agreement is still firmly kept in place as well.
And another area, Anurad, if I may add, is that we look at the labor component of it. And if there is going to be a discontinuation, we engage with the Labour Department to see that all their statutory dues are paid, that the gratuities and whatever statutory dues to the employees are also settled. So every aspect of that operation is looked at to see that there is no back
human capital that has been,
that there is nothing that really would boomerang on the people or that vicinity.
Exactly. I actually did want to touch on a specific area of curiosity when it comes to the employment as well. Is there some sort of quota that is mandatory throughout all businesses and investments in order to actually function in the country when it comes to national employment of Sri Lankan populace specifically? But before we get into that specific, I'd like to touch on what you just mentioned previously, which is tax breaks and incentives and also other legal benefits that investors can actually see. Could you please, ma'am, you mentioned that right now tax breaks are not something that's on the table at the moment. Could you walk us through other tax incentives that could have been, that are currently maybe in place when it comes to, and also exemptions when it comes to foreign investors, specifically in Sri Lankan law?
Yes, so through the BOI and through our Act, what we do allow for investors is the customs duty exemptions on their the capital goods as well as their construction material for companies that are not export oriented, but who would maybe be putting up a tourism hotel project, or it could be a hospital, it could be anything where during the construction phase they are allowed to bring in on customs duty exempted basis. But when it comes to companies that are, say, in manufacturing and who are export oriented, we also permit the raw material to come in on duty-free basis, because it goes into the end product and is exported out. So what we have in lieu of the tax holidays currently is a piece of legislation under the Inland Revenue Law, where enhanced capital allowance is permitted for 100% depreciation of fixed assets, where an investor invests anything over 3 million USD. So this is available, and once they have their taxable profits, they can deduct this 100% from year one of their commercial operation. So the 100% applies to the rest of the country. When it comes to the northern province, an investor can depreciate 200%. So that is actually a big incentive. It's maybe indirectly you can see it's a form of tax holiday, because these losses can be carried forward up to 10 years. So that, I think, is a major break for the investors who are investing over 3 million. Anyone below will not be able to enjoy this. And under the Inland Revenue, this is available for new enterprises. But because we have seen a tendency of our investors to expand their operations, actually we have companies that have been here over 35 years, right? So, and it is they who would be expanding their operations because they are comfortable with the business environment in the country. So in order to also give them more of a impetus to look at expansion possibilities, we have brought in a regulation through the Inland Revenue, where BOI companies who are expanding and investing over 3 million would also be able to enjoy the same 100% depreciation. So that applies only for BOI companies. So that is another benefit a BOI company would get. Similarly, if an investment is over 50 million US dollars, there is exemption from the port and airport levy as well as the cess under the EDB. So those are some of the key areas through which the benefits are granted.
Exactly. I mean, it's not tax haven, but we see that multiple areas exist where there's a little bit of a less of a burden, less of a strain when it comes to the initial investment as well, which in turn helps to foster growth in the Sri Lankan community also. Before we go into a break, very quickly, ma'am, you mentioned, of course, now these are recent updates, of course. When it comes to the recently updated tax regime as well, we saw when it comes to affecting investment specifically. Could you give us a little bit more information on the legal safeguards that are in place now? We see budget talks still continuing as well. Are foreign investors to be resting assured that the legal safeguards still exist within the BOI?
Yes, Anuradhi, I meant to give you an example when the rates in, say, corporate tax changed. Overnight,
yes.
But we had contracted with companies and we had put that amount. You would be taxed at 15%, for example. We honored that because we had discussions with the finance ministry, with the inland revenue, and they acknowledged, yes, because you cannot impose something afresh or retrospectively for investors. So that's why I said for the lifetime of the project that the agreements are signed with the BOI, we take it on us to honor those agreements. So investors, I think in that sense, that is why some investors, though they come in and they can operate maybe outside of BOI, but they want to come in because of the confidence they have in that particular piece of agreement.
There's
contract that we have with each other.
There's an added protection in having an agreement with standing with the BOI as well, specifically. Yes. I think I want to get into, well, we have to, of course, embark on the final segments of our discussion as well, specifically when it comes to human capital in Sri Lanka and how exactly maybe it could work the other way around as well, expropriation. When it comes to foreign businesses and how the BOI actually works on preventing that as well, and nationalization. But before we get into any of those specifics and also on the future of investment climate in Sri Lanka, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment.
Hello, my name is Himanda Sydney. I am a student in Gautami Balika Vidyalaya. So my question is, what we can expect as reform to the current investment law landscape?
Welcome back to Law, Land and Liberty. We're in our final segment with the Director General and CEO of the Board of Investment of Sri Lanka, Ms. Renuka Weerakone, Attorney at Law. Thank you very much for the previous two segments, ma'am. I believe we covered quite a lot of ground, specifically when it comes to foreign investment in Sri Lanka as well. Now I'd like to get into a little bit of a question. I believe it's a little bit of a can of worms. We'll have to have a completely different discussion on national investors, local investors, and also the growth of the national businesses in Sri Lanka. But I'd like to ask you specifically, before we get into the future aspects and everything, when it comes to foreign investors, one of their biggest concerns could be unintended nationalization of businesses and expropriation as well. Could you tell us, as the BOI and the laws that are enacted through the BOI, how exactly does the organization aim to prevent some sort of nationalization of foreign investment in order to ensure that their stake of the claim and ours are balanced appropriately?
Yes, so Anuradhi, I think one of the measures that this can be achieved is through the BITs and the FTAs, because that gives a very strong legal protection for such actions by the state. And in the event it does have to happen for national interest, there again there is a very well set out criteria how they would be compensated. So the idea of going into more BITs would also be a kind of a comfort, a confidence for investors that their investment is protected for number one, and in the event of an eventuality that something like an expropriation does happen, that there's a clear-cut mechanism through which they would be compensated. And also if you look at the FTAs, again the benefits of FTAs would be that the market access that it offers now, particularly for a country like Sri Lanka, where we have only like a 22 million population, it does not really attract an investor to come and set up here for purpose of the domestic market. So that's why it is very key that the FTAs we have with Pakistan and India, though we have not really moved much, progressed with the Pakistan one, but with India, I mean, it's a huge market access where when we are wooing a foreign investor, that is something we tell them, we have such a billion population next door. So you can set up here and you can, do your businesses in the country. Yeah.
So, of course, we have to use the geographic advantage as well. Specifically, I'd like to ask you a question, ma'am. Now, of course, we've been speaking about the foreign investors quite a bit. When you mentioned FTAs, I'd like to ask, naturally, the question that comes to mind is, when it comes to FTAs, it has to benefit local business as well. So, when it comes to local investors and their significant investments in foreign waters, does the BOI play much of a significant role when it comes to their protection and maybe their regulation?
Not directly, Anuradhi, because now we do have companies who have branches overseas, and if they are investing through the BOI company that has been set up, then when they need to take their foreign exchange out for setting up of that business, then they come to us because the exchange control is also handled by us. So within the guidelines of the central bank, the BOI also permits them to remit funds outside for setting up businesses. So there it is not really that we engage in terms of their protections per se, but we do assist them to take the funds out and set up, and again we have a monitoring mechanism where there's a reporting that takes place. But we see that in both sides, whether it is a foreigner coming in here because of the FTA provisions or the advantages, or someone going from here, we do see a lot of joint ventures and collaborations, which I think is good because the know-how, technical know-how, expertise, all that is also then a product of these both ways, whether they're setting up here or our people are going there, because finally the skills and everything comes back to the country. So in that context also we have seen that it has been very productive.
So Sri Lanka, at the end of the day, there's some sort of benefit, specifically when it comes to joint ventures as well.
Yes.
At the end of the day, there's some sort of value addition that's happening to the country. On an international context, ma'am, I wanted to check with you specifically. Now, Sri Lanka is, of course, involved with global trade bodies and also regional trade bodies, the WTO and, of course, RCEP. How exactly does this translate to investors, foreign and local, specifically for the international context? I believe it's important, of course, the WTO. Could you explain to us, ma'am?
Yes, so being part of those organizations would mean that the investors have a secure, predictable, transparent environment because they know these are the guidelines for trade and investment. So to speak, like the rules are set out and everyone would be following it, and if there is a breach of the rule, then there are also mechanisms through which it can be addressed. So exactly. That is the comfort and the confidence an investor would get by being part of such a big trading blocks, like say for example RCEP, because that would ensure that you have access to international markets, that the legal protections and the regulatory environments, all that is part of that trading block. So the benefits of being part of such blocks, I think businesses would really benefit in terms of being able to do transactions in a way that they know are going to be protected and rule-based.
Exactly. And I think this is one of the most important questions that our viewers might want an answer to when it comes to the value addition back into Sri Lanka through foreign investors. Specifically, you mentioned this, you raised this in the previous segment as well. When it comes to the human capital, as you mentioned, if they're moving to separate specific regions, they might be mandated to actually have in a certain number of workforce that's domestically brought into the enterprise. So I'd like to ask you, ma'am, specifically, are there some sort of hard set rules when it comes to a percentage of employment that has to be domestic through the BOI?
Yes, so we have a criterion that we follow. We don't really specify unless we are giving them a particular incentive. We cannot tell them you have to have 100 or 200. So it would depend on the application and of course on the mandate of their project to know how much they would require to be part of that operation. Yes, it will be case by case. So when they do submit the application, we ask them to also let us know how many expatriates that you would be envisaging to have in this operation and in what skill set that they would be looking at. So the BOI again is the facilitator for visas for any employment or for the owners or the shareholders. So we have a general rule where we say for every 10 persons that are employed locally, we would give them one foreign expat to come in. But that is not hard and fast. Like we would look at the operation and if we think they would only need 5, even if they have 500 people employed locally, we would only give them 5. So we are very conscious that because one of our mandates as the BOI, one is to bring in FDI, other one is to create employment. So, and of course to bring in foreign exchange through exports. So this is something that we are very conscious of. And sometimes we go to the extent of even, you know, asking them, have you advertised, have you looked for this post, why are you wanting from overseas? And so much so that they even bring us their paper advertisements and say, we've done our interviews, we couldn't find someone. So definitely, Anuradhi, we are conscious of that and we want to see as much employment generation locally as possible.
So it's not just for the foreign investment that there's an advantage. There is a genuine effort in order to ensure that Sri Lanka's domestic population also has some sort of advantage when it comes to foreign investments. Definitely. As you mentioned, employment and FDIs are the key yes. For specifically the BOI as well, and also for the continual growth of our economy, which is essential. We're nearing the end of the discussion, ma'am. I'd like to ask you specifically when it comes to foreign investors. I feel like we're focusing a lot, but of course that's where the importance lies specifically for our context and our conversation. When it comes to assisting investors, foreign investors, through Sri Lanka's commercial laws and corporate and investment laws specifically, how big of a role does BOI play in order to ease the process of making sure they don't fall into any legal lacunas?
Well, we do handhold them to an extent, but we wouldn't really go to that point where we say, okay, you should consult a particular chamber or a particular firm. But we do point them in the direction of the established firms, and it is, I mean, it is their discretion whom they would go with. But in instances where the BOI is also a party, in a case maybe where the investor is also a party, maybe together we are parties, so then of course that the support and the, you know, collaboration is
it's a team effort.
It is, yes.
So we can see that it's not, well, as you mentioned, there's some extent of hand-holding, but there is some sort of substantial support for foreign investors when it comes to navigating Sri Lanka's legal landscape specifically. A question of curiosity before we come towards the end of the discussion. This is a little bit of we're teetering on the edge here when it comes to political instability and political risk. Specifically, foreign investors might tend to look in that aspect as a big concern, as a big drawback in investing in the country as well, specifically with the recent past that we've had also. I'd like to ask you, ma'am, when it comes to Sri Lanka's legal framework specifically and also BOI's laws, are there any sort of provisions or regulations that assure safety even in times of political risk for foreign investors specifically?
It is not specifically like termed in that sense,
right?
But it is there for them. That's why I mean, would like to reiterate that, I mean, we honor whatever we have signed. So irrespective of changes in governments, that is upheld, and all successive governments have also, I mean, from now it's BOI is over 45 years old, so we have not had that allegation by any of our investors. So as far as that is concerned, it is, I think, a matter of their choice and their feasibilities that they come here, and the investors who are already with us are really our biggest ambassadors, because I mean, they have been through a lot in our country, but they have, you know, been here for the long haul, and they're quite happy with the environment, because I mean, even in the pandemic time, like BOI ensured that the workers were the first to get the vaccinations, to see that operations continued. And as you know, the port never closed even a single day. So business went on irrespective of, you know, curfews, and, you know, we issued curfew passes for all the employees, for all these factories to work. So things went on. So the investors have that confidence that they can count on us as an organization, as a government, to safeguard their interests.
Exactly. So even through times of distress, investors can rest assured, of course, that BOI will help deliver, especially for business as usual to continue. Unfortunately, I've come to the final question that I could ask you in the time limit that we've had. Ma'am, specifically looking future focused, could you tell us what legal reforms or maybe policy changes we can expect in Sri Lanka's laws in the near future or maybe in the far future, in order to better enhance the investment landscape of Sri Lanka, specifically, of course, not just when it comes to investor protection, but also transparency?
Yes, so I think we heard in the budget also that there's going to be an Investment Protection Act. So there, Anuradhi, I think most of the questions that we were addressing today would get covered by that, because there will be a separate piece of legislation to ensure that there's protection of their investment in the country. So that's something the BOI itself is really looking forward to, because that would be a great selling point for us in terms of attracting investors. And we also heard the announcement of the Public-Private Partnership Investment Management Act. So there again, it would pave the way for a new set of investments to come in the form of PPPs, because we don't have a legislation in that area. And we see that would be most applicable for the big ticket investors. So this would be a good foundation to, you know, look at the bigger investments that can come into Sri Lanka, the bigger projects that can come in. So we are really looking forward to that as well. So I believe, and the move for digitization, to have a special unit for that, a special authority for that, that also I think would pave the way to eliminate the scar of corruption and all those allegations, because once you do have systems in place, it is difficult for people to, you know, come in between to, you know, make unnecessary advances to investors. So those are key three areas I think that we can look forward to, which will help bring up the investment climate of the country, and will support to attract investors.
Exactly. So maybe in the future, once the laws are ratified, we can have you back at the studio to help explain specifically why the investment climate is safer and better than the last time we had to breach the subject. So thank you very much, ma'am, for taking the time to actually speak to us. Unfortunately, the duration has come against us to continue this discussion. Thanks once again for coming to the studio and explaining to our viewers. I believe we took away quite a bit from this discussion. Thank you once again.
Thank you, Anuradhi.
All right, well, we leave you tonight with the words of Benjamin Franklin. An investment in knowledge pays the best interest. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/Derana English. Thank you very much for watching. Have a good night.